Hello, friends and clients of Walker Gates Bella. I am Jennifer Walker Gates, immigration attorney, and I am here today with fellow immigration attorney at our firm, Diego Nuñez. Hey, Diego.
Hi, Jennifer.
Today we are talking about what to expect at your next master calendar hearing in immigration court. We have an earlier video where we talk about what to expect at the first master calendar hearing in immigration court. If you haven't seen that one, you should go back and watch it. This one is about what to expect at either the second or later master calendar hearing, which is, a master calendar hearing is a preliminary hearing to set the calendar and set dates and kind of get preliminary matters taken care of. But it's really, really important if you are in immigration court to understand what to expect and kind of how these hearings are going to be handled, what opportunities exist, and what responsibilities you have as a respondent in the immigration court. Before we get into this, I want to pause and ask everyone to please stop and hit subscribe to our YouTube channel. We do publish videos frequently, at least weekly, to update the immigrant community about rights and responsibilities, important information and updates. We want everyone who is in the United States and deserves to have legal status to be able to get that, and to have that, you need good information. So please subscribe, share our channel, like the video, leave comments if you have them, and we're happy to answer questions. So with that, Diego, in your experience, after that first master calendar hearing, what happens at the next hearing?
To refresh what happened maybe at that first hearing. And in our last video, we spoke about requesting a continuance if you're not represented, if the judge usually giving that continuance. Let's say that continuance has been given at that first master calendar. At that second master calendar hearing, the judge is going to want you to plead to the notice to appear. And the notice to appear is the document that the government has issued to the court, has submitted to the court to begin that deportation proceeding. The notice to appear, or the NTA, has very basic information. And it might state, your name is Diego Nuñez. This is your address, this is your phone number, this is your date of birth. And the judge will ask you about whether that information is correct. And if you're represented, the judge is going to ask you if you want that attorney to represent you and to speak for you. If you're not represented, the judge then might go into what your rights are. And, you have the right to counsel, but at your own cost. You have the right to submit evidence. You have the right to review the evidence that the government has against you and that kind of thing. And then you'll plead to that notice to appear, and you can admit or deny what it says. And, it usually has just 4 lines. And it might say, Diego Nuñez is a, native and citizen of Costa Rica. He is not a U.S. citizen or a permanent resident. He entered the United States without admission. And then, for these reasons, he's deportable. And you can admit or deny. And I could be like, well, wait a minute, I'm a permanent resident, and well, then that's going to create a whole other issue. But you can admit and deny. And then the points that you deny, the government is going to have to prove, and the judge will rule on it.
If you deny, now what happens if there's something on there that says, okay, Diego Nuñez is not a citizen of the United States. He's a citizen and native of Costa Rica. And you know that that's true. But what happens if you say deny? Are you lying, or do you have a responsibility to admit it if it's true? Or what do you think about that, Diego?
Well, so some immigration attorneys, take the position that you should deny everything. And a lot of people talk, usually at CLEs, about how that's how you should always do it. We don't always do it, and we can be strategic about it. And so you can, and it's not lying. It's just saying, you know what, I'm going to flip the burden on the government to prove that that I am deportable and that I am from Costa Rica, and let's see what that evidence is. And so then the government will provide that evidence, and then the judge will rule
if they have it. Sometimes the government has zero evidence other than a statement, maybe that's taken, when you were picked up by the border or something like that. And maybe that's enough. Maybe the judge will find that is enough evidence, but maybe you can also say that's not enough evidence. Look at this error in this document. There's another error in this document. You can find problems with those documents. A lot of times And, you know, it is, this is very technical information. So again, it's, you know, I think it would be tough for a person without an attorney to deny the allegations in the NTA if they were in fact true and the person knew it. But as a matter of legal strategy, it is open to you, even if you are not represented, even if you're representing yourself. And it just, you know, it can sometimes create opportunities for you to get out of the removal proceedings if that's what you want to do. You don't have a way to win a benefit in the court that will allow you to stay lawfully in the United States.
Again, this is why it's just better to have an attorney. But I was just talking to somebody about on a different topic, but it's okay to admit when you don't understand things. And so if you're representing yourself, if you're going there on your own and the judge explains something to you and you don't understand, but the judge says, "Did you understand that, Mr. Nuñez?" And then you say, "Yes." Well, maybe you don't understand. And so it's okay. You can be like, this is going to date me, but like Columbo, you know, can you explain it to me? You know, it's okay to not know something that is not what you normally do. And it's okay if you don't, you know, some people are visual learners and some people can learn by hearing and understand things by hearing. And a lot of clients hearing something for the first time and it's being interpreted by the interpreter on the headphones. So then you're hearing it in English and you're hearing it in Spanish or whatever your language might be. And it's okay to be confused. And so then if you don't know, it's okay. You know, I'm sorry, I don't know. And let's say that you're afraid, you're from Guatemala and they ask for the country of deportation and you're afraid to go back. And they say, well, what country will you designate if in case you are deported? And so then you can say, you know, I don't want to designate a country. You know, if you have no right to go to any other country, or maybe you do, maybe you have Spanish citizenship. So you can say, well, then I'll go back to Spain then. You know, you guys can pay that bill. And so well, that goes to the point that I just kind of jumped. Once the allegations are admitted or the government is able to prove the allegations, the judge will make a finding whether you are deportable or not. And so then the judge will say, well, Mr. Nuñez, I find you deportable. What country do you designate? Costa Rica. And then they'll ask, what will your defense be? And again, if you're on your own, you could say, you know, Your Honor, I don't know what my defenses could be. Can I have more time? Can I find an attorney? Or the judge might ask you some questions, and the judge might ask you about how long you've been in the United States, and if you have family that are citizens and things like that. And sometimes the judge will say, well, you know, it looks like you might be eligible for cancellation, and then they'll tell you to get that cancellation application in. Or they'll ask you questions about fear of returning to your country. That might be asylum. There can be, you know, various different defenses that you can provide. And again, just another reason why you should have an attorney.
Before we even talk more about the different types of defenses that can exist in the court, I wanted to circle back a little bit to that notice to appear again, because at this point in time, you know, here in October of 2022 is when we are recording this video. We have a pretty recent case from the BIA about when that notice to appear has a problem, and what can come of the whole hearing if the notice to appear has a problem. That case is matter of Fernandez. And Diego, I was going to ask if you could explain a little bit about what does matter of Fernandez say, and how should people check to see if their case could be terminated under matter of Fernandez?
Essentially, matter of Fernandez is dealing with what the court will deem a invalid notice to appear. And so because the notice to appear is the document that's placing you in proceedings, it's what gives the court the power to hear your case. If that document is not valid, well, then the court really doesn't have the ability to hear your case. And so then the challenge would be over jurisdiction. And Matter Fernandez says that it's a claims processing issue, and you have to challenge the notice to appear at your first opportunity. And so this case was issued in August of this year. And so for many people going into court now, well, this is the first opportunity that they're really going to have to challenge it. Although some may have challenged it in the past, and it was overruled on whatever grounds. The issue with the validity of the document is that for many years, the government was issuing the notice without the date and time of the hearing that you have to go and appear before the judge. And that's a statutory obligation. And so some people think, well, it's not a processing claim issue, it's an actual statutory issue, but whatever. Either way, what you can do is say that this document is not valid. And many judges.
When do you do that? Do you do that before you admit to the allegations in the notice to appear, or after, or?
Well, it depends on where you are in your case. And so then if this is the first time that you're appearing and you've already pled to the notice to appear, you can challenge it still. If this is the first time that you're going to make those pleadings, then you challenge it at that point before you take pleadings. And you can say, the document is not valid. And
if it says to be set, or it doesn't contain an actual date and place and time at the bottom of your notice to appear, if it says to be set instead of a date or a time or place, that's how you know that the government made an error when they issued that document. And according to this case, matter of Fernandez, a couple of things could happen. You can certainly ask for a correction, but if you're wanting to get that case dismissed, you have the right to ask the judge to dismiss the case. If they wrote to be set, or if they left it blank or wrote unknown or something like that. Most of the time in the cases that we've seen for many, many years, and thousands and probably millions of these notices to appear, immigration would just write to be set on the time and date line. And what Matter Fernandez says is that is not acceptable. That is not sufficient. You have to do a better job than that. What immigration has always done is just relied on the court to figure out the time and date of your hearing, and then send you a notice that you can then use to kind of fill in the blanks that they didn't fill in. But what this case says is that isn't good enough. The law requires immigration to figure out the time and date of their hearing and put it on the document. Otherwise, the document isn't valid. And so if you have a hearing where you haven't yet had the chance to make this case to the judge, check your notice. If it says to be set in those lines, and it probably does, if you're in court proceedings these days, many of those do. Sometimes they have a fake date. Sometimes they have a fake time and date for the hearing. These, since we started going to war over this, immigration has started trying different strategies to deal with this issue. But the system that they've always used for getting people into immigration court, is just not working anymore. And that is what this case means. And if you can use that to your advantage, we want to make you aware of that. There is a case right now where you can ask the court to dismiss your case if the government didn't do their full job of preparing that notice to appear for you.
The regulations state who can issue that document, and that attorney right next to you, that government attorney, is not able to just white out and change that date and just put, oh, well, today's date and today's time. They're not able to do that. And even though the matter of Fernandez does say that the judge can give additional time to correct the situation, they're completely limited on how they can correct it. In my opinion, how can a judge give additional time when they don't have jurisdiction to hear it? It just blows my mind. And I just heard I met with someone yesterday whose case was originally terminated for this reason, but the Board of Immigration Appeals had not done matter Fernandez, and they reversed it and they reopened it, and he went on his own for his final hearing. And he actually had a good cancellation case So maybe one of those cases where we would have ignored it and gone forward with it, could have brought it up, but he didn't know that he could. And, the point of appeal that I might argue is that, well, the judge was already aware of this. It was already closed before. It's kind of hard to, judge can't really advocate for an individual, but the judge also has to be fair. And justice demands it. And my argument would be that the judge should have noted missing date and time and should have explained to the individual his options. And then the individual could have made that decision representing himself. That didn't happen. And now he's, facing deportation. So,
Yeah, again, very, technical information, but hopefully helpful, especially if you cannot have an attorney with you. There is some stuff you're going to need to learn to be able to manage your case effectively. And so the other thing that, we were going to talk about, and you touched on, asylum, cancellation of removal. There are various different types of benefits or forms of relief that you can apply for in the immigration court to prevent yourself from being deported. One of those that is available right now that hasn't always been and may not always be available is prosecutorial discretion. And that is another opportunity to potentially get your case closed. Diego, explain a little bit about how prosecutorial discretion works. I don't know that an unrepresented individual could do it, but maybe they could by speaking directly to the government attorney at the hearing, for example.
right.
Yeah.
Well, so the government had laid out its how it would review and consider dismissing cases on its own. And then that was stopped by a federal court. And so it's still an option. It hasn't been taken away, but to have a national policy has been taken away. And so it really depends on who you're with. And sometimes it depends on the judges, because I've heard that some people in the East Coast have been facing some judges that are not dismissing the case, even with the support from the government. The way that I've seen actually communicated with the ICE attorneys lately, they want to know if there's any other form of relief, so they want to know, well, your individual, like, does he have a family, or does does he have the ability to get residency in another way? That will help them make that decision. What a lot of attorneys have been doing, though, is that they'll just, for the San Antonio court, they're just challenging under matter of Fernandez to just kind of cut that out when there's no agreement to dismissing the case. Let's say that I'm married to a U.S. citizen and she has filed a petition for me. Well, so then the petition so I can get an immigrant visa and get my permanent residency. Well, that is enough for some of the prosecutors to dismiss. For others, they want to see that the petition has been granted, and then they will request for the case to be dismissed. And that's one way. The other one is just trying to show positive factors. And, so that, maybe you do have family, U.S. citizen and permanent resident family connections, but no one that can really help you get your status. Showing that you're a person of good moral character. So, you work and you report your taxes. Maybe you've been part of your own community for 15, 16 years. I had a client that was facing potential deportation. We were just in the naturalization process, but he was deportable. He filed on his own and then came to me for help. And when I asked him for evidence, just to show like discretionary evidence to help, he helped support his children's high school band, and he helped support the first high school mariachi band. And then I learned that he was the soccer coach for his son's team, and it was a team for autistic children. So this guy had done a lot of mistakes in the past, and he more than made up for it, in my opinion. And so that was the opinion of the officer, and they agreed to not place my client in deportation. And those are the kind of factors that they'll look at to also deem it if you're worthy or not. And it doesn't have to be like those great humanitarian gestures to be granted. You can be granted just because you've got no arrests and you've been here for maybe 8, 9 years, and you've got a baby daughter. And
I had one recently dismissed, who doesn't have any actual, right now, no relief available. Now, that doesn't mean that in the future, she might not get married to potentially a US citizen, or, maybe one of her parents might become a US citizen, maybe one of her children could, petition for her if she has the ability to get the waiver and all of that. All of that information, we can talk about in a separate video as well. But, that just having worked hard, she had taken a couple of English classes, and been a good mom, to her children, and filed her taxes, was enough for ICE to agree to dismiss her case. And I think there are, she really didn't have the factors present in her case either to be able to qualify for cancellation of removal, which, as we know, is incredibly stringent in terms of the hardship that you have to show to be able to win. So sometimes, the best thing you can do is ask for ICE to dismiss your case, so that you're not facing potentially losing your case and having an order of deportation. Because, as we'll talk about in the next video, when we talk about the final merits hearing, or it's called a merits hearing or an individual hearing, that last hearing that you have before the judge, where you do present your case and you ask for the judge to grant you a benefit or a relief from deportation. If you win, you get some kind of status to stay in the United States and the ability to remain. But if you don't win, and it's never a guarantee that you'll win, if you don't win, then you get an order of deportation. And it's not to say that you can't keep fighting and that you can't appeal. It's not to say that you're going to get snatched up right there at that hearing and taken to the border immediately, or put on a plane, or even put in detention. That is not going to happen. If you don't have the ability to win and you don't feel confident in your ability to win, you may want to get your case dismissed so that you don't end up having the stress of that order of deportation entered against you, because that is what will happen if the judge doesn't approve it.
One point to make regarding requesting prosecutorial discretion is that it's not enough to say it. You're going to have evidence to back up what you are saying. Again, this is why people need attorneys.
It is.
But
I mean,
you know what?
I don't know how an individual who's unrepresented would be able to effectively request it unless they had the documents in their hand at the hearing, speaking to the government attorney. But that government attorney isn't going to have the authority most of the time to make a decision right on the spot based on documents that you've just given them. They're going to need to review things and correspond with you by email, and kind of go back and forth and ask questions. So if you're not represented, it's unlikely that the government attorney is going to do that.
Now, there are some nice attorneys there. I mean, so you might get lucky, but
there are some not so nice ones too. In short, to sum this all up again, second or another intermediate master calendar hearing, you're probably going to be expected to enter pleadings to the notice to appear. Before you do that, we encourage everyone to check your notice to appear to make sure it's valid. If it's not valid, ask for, matter of Fernandez to apply to your case and ask for your case to be dismissed if you can. Once you get those pleadings done, the judge is going to ask you what kind of relief you're going to apply for. If your case doesn't get dismissed, the judge is going to say, okay, what do you have for relief? And you may not know. The judge might have to explain to you, but probably before you leave that hearing, you're going to have to tell the judge, like, I'm applying for asylum, or I'm applying for cancellation, or I'm going to ask for voluntary departure. If you do have an attorney, your options for what that relief is going to look like are going to become more broad, and you're going to have more opportunities to ultimately stay in the United States, even if you don't win a benefit from the court. Those benefits from the court are really, really hard to win in many cases. Sometimes they're not as tough to win if you're just applying for a waiver, or you qualify for adjustment of status and you're applying for that in the court. But for cancellation of removal and asylum, man, those standards are really, really high. And so it's just important to know kind of what you're dealing with, how you can best advocate for yourself if you don't have an advocate with you. But if you can possibly hire an attorney, please do so. Your chances of being able to remain improve dramatically if you do have an attorney. And then at the end of that hearing, if your case isn't dismissed, the judge is going to set a date for your next hearing, and that will probably be your individual hearing date. And Diego, I thank you for meeting with me and talking about this today, and I look forward to the next time we do this so that we can share with everyone about what to expect at that final individual hearing. In the meantime, if you have questions, concerns, needs, if you need to consult with us, if you need someone to help you in the immigration court, please reach out to us. You can find us on our website at walkergatesvela.com. On our website, we have a button at the very top. You can click to schedule a consultation. You can schedule with Diego, you can schedule with me. Either one of us would be happy to assess your case and let you know kind of what strategy we think would work well for you. Whether you can hire us to represent you or not, we're happy to assist and give you our honest opinion and assessment of your case. And is there anything else, Diego, that you want to tack on before we sign off?
No, I mean, I think you nailed it. You know, I guess the one thing that I can think of is that I've talked to several people that have said it's very hard to speak to an attorney about their case. So don't wait for the last minute, you know.
Oh,
Talk
yes,
to someone
that's right.
soon.
That's right. Yes.
Yeah.
Great advice. All right. Thank you, Diego.
All right.
Thanks to everyone. Please stay safe and well, and we will see you again next time.